Hey everyone, did you know that there's a big difference between patent prosecution and patent litigation? Hi, I'm JD Houvener, owner and founder here at Bold Patents Law Firm, and we're going to go through the differences between prosecution and litigation when it comes to patenting, and what you can expect along 6 different categories. So the first one, the nature. What's the nature of patent prosecution? Well, prosecution means the getting of the patent. So there's a lot that goes into getting a patent for your invention. First and foremost, research, application drafting, then you submit it to the patent office and the USPTO examiner gets their hands on it. They'll do their own search, they perform an examination, and usually about 90% of the time they'll find something to reject. And so this is the prosecution phase where the attorney that's representing you, the inventor, will help you put together legal arguments or structure changes, amendments to the application, usually to the claim language, to get around the examiner's rejections or objections. This could happen 2, 3, or more times from the USPTO examiner. Now, this process can take upwards of 1 year to 2 years before your patent is granted. So all that time from invention, disclosure, all the way through patent searching, applications, and office actions, that's called patent prosecution. Now, once your invention and once your product hits the market, this is when litigation can come into effect, when you have to enforce. So the nature of patent litigation is once there is infringement or even alleged infringement. That's when pre-litigation can begin. This phase is where you start conducting infringement opinions or going forward and starting to talk about whether the patent itself is valid under the current laws. It's true that a patent can get through the prosecution phase and get granted, but still be subject to different laws. The patent law can change. One of the biggest ones I can think of was about 10 years ago when abstract ideas or software that was merely human activity now on the internet is invalid. So all this time before 2014, patents were getting granted for software that was truly abstract. And the law hadn't changed until 2014 in Alice v. CLS Bank in a landmark decision that says, you know what, all those patents that were issued before, they can be invalidated now. Anyway, so that's pre-litigation, where patents are subject to infringement, validity, invalidity questions. And once you get to federal court, that's when a patent holder is suing and would-be infringer, not just to stop them from making, using, or selling their invention, but to seek damages. Now, litigation can also extend to customs using the ITC, the International Trade Commission, and customs, so at the border, stopping products from moving into the country to be sold. This actually really famously just came up a few months ago where Apple got in trouble with their Apple Watch. The O2 sensor inside their watch was an infringement on a patent that was owned separately. And so because that component is within that watch, customs stopped the whole shipment of all the watches into the US. It's a huge battle happening right now. All right, what's the objective? Well, patent prosecution, the objective is to get a patent. Patent litigation, the objective is to get money or stop the infringement. So an injunction is to prevent the activity of another party that might be infringing, making, using, or selling that product that's patented. Now the time frames are different too. Let's look at that. So on the patent prosecution side, like I said, it could take up to 2 years plus just to get the patent granted. Now patent litigation, you can also say could take a long time too, but usually the threat of litigation is what actually gets the most oomph, right? Most bang for the buck. Inventors, companies on either side, they don't want to just pay the attorneys to go to court. They'd rather handle it much more efficiently through settlement. So within 6 to 9 months, typically, a patent infringement case can be settled outside of court. Let's talk about cost. So cost is important. So to you, the inventor, to research, apply for, go through all those different office actions, you can plan to spend between 10, 30, or 40 grand acquiring a patent portfolio. Now, cost on the litigation side, this can depend dramatically. On the low end, it could be as simple as a few $1,000s sending a cease and desist letter, and now you have no more infringement. Then again, on the other side, it could be a drawn out legal trial that could be in the hundreds of thousands of dollars, approaching $1 million. Let's say if it goes to the federal court or even to the Supreme Court. Now, complexity. There's different layers of complexity. On the prosecution side, it's much more technical. It's about, is this invention truly novel? So all the details with respect to what it is at its very finite level to compare, has this been done before? So that's what the attorney will work with you and the inventor on, is articulating all those different nuances, applications, and details. On the litigation side, the complexity is not so much technical, so much as it is about the legal, right? The facts, the evidence, and even sometimes expert witnesses. Their opinions as to whether there's really use or what the term is in the claim, and analyzing that term specifically to whether that matches the product that's on the market. There's also, of course, the judicial complexity with procedures, submitting evidence, generating court documents, and pleasing the judge, whatever route they want to go. So, the last major section is, what's the role of a patent attorney in either one of these? On the prosecution side, it's giving an opinion, first and foremost, on should you file a patent application. A patent attorney can give you that legal opinion, that insight into what the examiner might find once you spend that time and energy filing an application. On the other side, a patent attorney can represent you in court, and they can also be right there by your side, helping you make decisions on, do I send a cease and desist letter? Do I settle? Or do I go for it and try to reach a pinnacle of damages, a certain set of goals at the judicial level? So I hope you learned something about the difference between patent prosecution and patent litigation today. I'm JD Houvener, owner-founder here at Bold Patents Law Firm. Wish you guys a great day. Go big, go bold.